Namaskar. I am Assistant Professor Kritika Dev from LJ School of Law. Today we'll be dealing with Indian Evidence Act 1872. Now you must be not be you must have heard the term evidence very often, but there are so many rules when it comes to evidence. There are in total 167 sections, and we will be dealing from section 40 to 167. And we will be having different videos for different topics. So when it comes to today's video, we will be reading the relevancy of judgment. Something things are must not be much familiar to you, but of course, after this very lecture, everything will become just a cakewalk. So let's move on to the very topic. So when it comes to relevancy of judgment, as I said, there'll be number of different topics. But if I'll give you the overview here, you'll get really confused. So today, let's stick to this one topic and move on with this one topic. So as I said, today we'll be dealing with relevancy of judgment. Now, relevancy. Before moving on to this very point, I would like to tell one fact to you that when it comes to relevancy, relevancy is basically being defined from section 5 to section 55. Now, what are these sections? These section talks about the relevancy of different points under different sections. So one of them is relevancy of judgments. Now, what do we understand by relevancy here? If these things are there, right, when it comes to relevancy of judgment, means when it comes to this topic, then if that judgment becomes relevant, then the evidence related to that can be produced before the honorable court, right? You must have heard people saying that, you must have heard in the courts, if you have visited, that court generally asks the advocates, how is that relevant to the case? Now, if you want to prove your relevancy, your topic has to be somewhere between section 5 to section 55 of the Indian Evidence Act. If it does not fall here, then you cannot prove the relevancy. And thereafter, how will you produce the evidence? So, if your points fall in any of these categories, in any of the relevancy mentioned from section 5 to 55, then you can produce your respective evidence. So here we will be talking about relevancy of judgment. How judgment suddenly becomes relevant in the present case, and once they become relevant, how can you produce the evidence regarding the same? So here section 40, 41, 42, 43 and 44 talks about the relevance of judgment. Now here we'll see section 40. Now section 40 says previous judgment relevant to bar a second suit or trial. Now what this section is trying to say is, let me not read everything to you, but it just says that the previous existing judgment. Now what the existence of any judgment, order or decree, right? Now the previous, there had been a judgment, order or decree which prevents the present suit, or which prevents the court from taking cognizance or trying out a suit. It prevents the present judgment or prevents the court from taking the cognizance of the suit, because there wasn't judgment, order or decree which actually bars such present suit or decree. Sorry, present suit, not decree. Now, how does that happen? Now, let me give one example to you. Now, before moving to the maxims, we'll see these things, right? We'll see the maxims later on, but we'll see this thing first. Now, this thing talks about doctrine of res judicata. Or if not doctrine of res judicata, you must have heard the principle of double jeopardy, right? When it comes to these three things, when it comes to doctrine of res judicata, so when it comes to the doctrine of res judicata, it bars a present suit on certain grounds, right? So the provision of this very section is trying to say that the present suit is barred because there had been a previous suit. Now, when it comes to res judicata, what does that mean? It is a principle, it is a doctrine which is mentioned under section 11 of Civil Procedure Code, which says if there had been a previous suit, there has to be a previous suit, between the same parties. Here, same parties means the parties which are presently trying to uh, presently they are there in the court in order to or in want the court to take the cognizance. The parties are the same. In the previous suit also the parties were the same. The matter in issue was the same. Here is also the matter in issue is the same. The court had the jurisdiction, the one which actually pronounced the judgment, order or decree in this case. Now when there had been a previous case with same parties, same matter and everything, why will the present court entertain the same case? Here we are not talking about appeal. Kindly mind it. We are talking about the same case, the trial of the same case. So the doctrine of res judicata actually stops the present court from taking the cognizance of the same case where the judgment or decree or order had already been pronounced. So it stops the trial of that very case. Right? The same principles have been discussed under Article 20, Clause 2 and Section 300 of CRPC, which actually, which says that one should not be prosecuted once again for the same offense twice. Right? When the offense is single, then one shall not be punished or prosecuted for the same offense twice. Right? If once punishment is being given, or maybe acquittal or punishment whatsoever, but if once trial had been commenced and after that whether there had been an acquittal or there had been the conviction, then on the same grounds the trial should not commence once again and the person should not be punished on the same fact and issue. You're getting my point? So when it comes to this very section, it actually bars the present suit because there had been already a trial on the same matter and issue between the same parties. So it does so in order to reduce the number of cases. Of course, there are already number of cases here in the country, so it reduces in order to reduce them. So here are two maxims which are relevant to it. The first one is interest republicae ut sit finis litium. It simply means that it shall be in the interest of the state that there should be end to litigation. It does not mean that it is trying to say that litigation should not be there at all. No, end to litigation as in multiple litigations on the same ground, right, as we have discussed in the section. And the second one is nemo debet bis vixari pro una it idem quasi. It means no man shall be waxed twice for the same cause, right? No one, as we have seen, no one shall be punished twice for the same offense, correct? So these are the maxims in support of that very section. So now let's quickly move on to the next section, which says, that is section 41, which says relevancy of certain judgments in probate, jurisdiction, etc. Now, in order to understand this very thing, let me read that very section to you. A final judgment, order or decree of a competent court in the exercise of probate, matrimonial, admiralty or insolvency. So there are 4 points: probate, matrimonial, admiralty or insolvency jurisdiction, which does what? The first one, confers or takes away from any person any legal character, whether it confers or whether it takes away the character of any legal character of a person, or which declares any person to be entitled to such character or to be entitled to any specific thing, right? Then when such legal character or such title is in question, then this is the, or this thing is the conclusive proof, right? So let me tell it to you, the important thing: probate jurisdiction, matrimonial jurisdiction, admiralty and insolvency. So for say, if there is any case related to these 4 matters, right, when the case is related to these 4 matters, then supposingly let's take an example of the matrimonial jurisdiction. For say, if A and B, they are married, right? Then if they are in the court for the marriage certificate, now they have got the legal status of being married. Now if the legal status is now in the present case is in question, then they will produce the marriage certificate, and by that it will be conclusive proof, which means in the present case the court will not allow the other party to give any kind of evidence related to their legal character. because that legal character in the previous judgment or order is now a conclusive proof. Right? Same goes with the probate jurisdiction. Probate is a document, right? A document that you get from the court, which is which proves the legality of a will, right? And the jurisdiction of admiralty lies with the High Court. When it comes to insolvency jurisdiction, it is simple to understand that once a person who has been declared insolvent in the previous judgment, order, or decree, then in the present case, if somebody questions that insolvency once again, then that previous judgment, order, or decree of that insolvency, that legal character has been taken away from a person. Now that person will be termed as an insolvent. So if somebody else files a case, now this insolvent character will be a conclusive proof here in this case, and court will not allow to give any evidence other than this. This will form a conclusive proof. With this, let's move on to section 42 of Indian Evidence Act. Now, what does that say? Relevancy and effect of judgments, order, or decree other than those mentioned in section 41. Right? So here, what this section is trying to say is, judgment, order, or decree other than those mentioned in section 41 are relevant. When it came to section 41, they were the conclusive proof. Right? Here, they are relevant if they relate to matters of public nature. Right? So if there had been a matter of public nature, then in the present case also they are relevant. Now let me give you a quick example. First, say if there is a matter of public nature, let's see A and B, the characters here, right? Let's not give them a name, A and B here. Now A is saying A filed a case against B for trespass. Right? A filed a case against B for trespass. Now B is saying that is a public way. I have not trespassed. That is a public way. Right? So of course it is relevant to a case related to public nature. If it is a a public path, then of course it is of a public nature. So B is saying, no, I did not trespass. That was of a public. That was a public way. Now in this case, B won the case. It was there that it is a public way. Now in the another case of that same land, if A again files a case of trespass against C, right, against C, then here the judgment, the order or decree between A and B will be relevant in this case. You're getting my point? So here that previous judgment, order, or decree will be relevant here. So they can produce an evidence. The other party can produce an evidence by saying that no, there had been a previous case like this and it was declared as a public way. So it will be relevant. It will not be a conclusive proof, but it will be relevant in this case. Now comes section 43 of Indian Evidence Act. Now what this section says, that judgment etc. other than those mentioned in section 40 to 42 when relevant. So this section would actually like to say one simple thing, that when it comes to the relevancy, they are relevant, they are irrelevant. Though, when there is anything other than this, they are irrelevant unless the existence of such judgment, order, or decree is a fact and issue or is relevant under some other provision of this act. So if other than this, the judgments won't be relevant. But if it is related to the fact and issue, of course, the fact and issue in the present case, right, on which we are actually filing the case, on which we are actually fighting or two parties are litigating, that is fact and issue, right? For say A murdered B, right? So that is the fact and issue, whether A murdered B or not, correct? So the previous judgment, order, or decree will be relevant if it is relevant in any of the provisions. So any of the provisions would be from 5 to 55 or related to the fact and issue itself. So it is a very simple section to understand. The last one is the previous judgment, order, or decree. When will they be relevant? Right. So now here what this section is trying to say, let me read the section to you very quickly. Any party to a suit or other proceeding may show that any judgment, order, or decree which is relevant under section 40, 41, and 42 and which has been proved by the adverse party was delivered by court not competent or was obtained by fraud or collusion. right? So these are the important things here: want of jurisdiction, fraud, or collusion. So in the present case, if you see the present case here, so if they prove that the previous judgment, right? Supposingly this is actually creating a bar, right? This is creating a bar. Let's take the example of section 40. This is creating a bar. But now if they prove somewhere that the previous judgment was given by a court which had no jurisdiction, then this bar will be taken away and the court will entertain it. Or if they say that the previous judgment, because of which you are barring the present one, was obtained by fraud or was of collusive nature, then the present court will find it relevant. These, these things, if any of these things are there, and then the court will entertain that very suit. So therefore, the previous judgment is relevant here, right? I guess, of course, this is so much there, but I hope you must have understood it. And this is about the relevancy of judgment. So in the whole session, we were talking about relevancy of judgment. So we had seen section 40, 41, 42, 43, and 44. These 5 sections talks about relevancy of judgment. And with this, I would like to rest my lecture. Uh, as I always say, keep studying, keep reading, keep your books open. And when it comes to evidence, you literally need to sit with the bare acts. Yes, that is my suggestion to you. Next time, whenever you are taking my lecture, kindly sit with the bare act and with a notebook in order to note down the points. Right? Thank you for listening.